Let's start from here. Mr. McCloskey, would you just state for the record who else from your team is present now? Because I can't see everyone from behind the column.
Caitlin Chitlenden, Chris Mitchell, Rupert Elderkin, Lada Sholyan, Kweku Vanderpuye, Janet Stewart, and Nelson Thayer.
Okay, thank you. As we said, we have a series of questions which we will put to you. If for any of these questions you need time to do your homework, of course you will tell us. We are not going to indicate to whom in particular any of the questions is directed. You choose who will answer the question. Judge Prost.
Thank you. To begin with, I have, Mr. McCloskey, some questions relating to crimes against humanity, in particular the chapeau requirements for crimes against humanity. I'll begin with a very general question related to the attack, widespread and systematic attack. Now, yesterday, Mr. Elderkin made reference to the prosecution's position being that the attack on Srebrenica constitutes the widespread or systematic attack on the civilian population, and I presume that relates similarly to Zepa. What I'd like to know from you is, what is the prosecution's position as to when that attack commenced? I'm not talking about the JCEs here, obviously. I'm talking solely about the chapeau requirement and the prosecution's position as to when the widespread or systematic attack on the civilian population began. And as Judge Edgius has indicated, if in any of these questions you want to consider your position, you can certainly let us know that.
Your Honor, that we had actually, it's one of the legal issues we had discussed among ourselves and looked carefully into the Kirstich judgment and the appeals judgment and their findings relating to that, but I cannot right now immediately recall whether we considered the attack, and I know attack doesn't mean necessarily firing bullets and artillery, whether or not we believe the attack starts with the squeezing and the formal start of the indictment from Directive 7 in March, or we begin it with the actual operation. I would have to consult on that one. But give me 1 second. Your Honor, in our trial brief at paragraph 2868, we talk a bit about this, where we say it's inconceivable that the very person engaged in the attacks upon Srebrenica and Shep enclaves in July '95 could not have been unaware that these widespread attacks were taking place. Indeed, evidence established that all the accused must have been aware of these attacks owing to their intimate involvement in various, and in some cases all aspects of the attacks, including first, the restrictions of food and aid entering the enclaves, then sniping and shelling, further forcibly displacing. So that is the position. I couldn't recall, but we did start it with the restrictions as were formally placed in our view by Directive 7.
So Directive 7 as the starting point is your position?
Yes, and as we've set out, I think very clearly in the indictment, while this business was going on for quite a while, Directive 7 is where we wanted to focus the court's attention for the targeted charge of forcible transfer, the attack beginning with that pressure and the sniping and the restrictions, et cetera.
Thank you. Now, the second question also relates to this issue of the chapeau requirements. And you have acknowledged, and it's clear and it's mentioned in several of the briefs, the point related to the column. I'm moving now to the column. You have acknowledged the military nature of the column, albeit with a civilian component to it, but the existence of the column as a military column subject to military targeting. So my question is the relationship or the nexus between the military column and what you have alleged to be the attack on the civilian population. So my question to you is, what is the nexus between that military column and the attack on Srebrenica? And is it a sufficient nexus to bring the actions against that column, the alleged crimes against the members of that column, within the concept of crimes against humanity?
First of all, let me try to clarify the position on the column. Many times, and I think I've been quoted in various briefs when I stand up in court and talk about that, and I of course stand by everything I've said, but many times the context of that is me acknowledging a particular reality, and I'm not necessarily making an overall statement. Usually I get up and say, and I recall Judge Aujus and I having a discussion on the record about this, is that the head of the column certainly was military, and as such was a fair target. But we also see a tremendous number of unarmed and non-military men and boys within that column, even women we see. And there becomes a very gray area for us about when that can be attacked and when can't it be. And we have clearly a partial armed column moving through the hills of Kravica. Then we have these people surrendering and getting blasted by anti-aircraft guns. That is clearly not, in our view, a fair target of the column when people are being asked to surrender and are being blasted by anti-aircraft gun fire, even though that is the column. We've never chosen to charge that crime or that crime of perfidy in this case. We don't know who was killed up there, but it's not an absolute that this column was fair game and a fair military target. Parts of it were. It's in a gray area that we did not choose to go into as prosecutors in the indictment, but because as the elements went through and broke through Serb lines, they clearly could be fought. Now, that group with its military command, we believe were part of the group that were forced out of fear of their lives. Now, this is similar to the Jeppe situation, where we have a retreating, largely force of able-bodied men. They are victims in this case, in our view, even though they are part of a fleeing force. It's a mixed force. I don't think there's any question factually that this is a hugely mixed force. You get excellent pictures of this as they're coming out into Zvornik. There's a few guys with rifles, and then there's this pathetic group of men, young and old, with no guns. So it's a mixed force, and these mixed guys with no guns and that are no threat to the Serb forces are clearly just as much as victims as forcible transfer as the men that went to Potocari and got kicked out. The fact that they chose to run for their lives doesn't make a difference to us. The same thing with the military people. Yes, they are a target, but when the intent of the perpetrator in this case is to forcibly and permanently remove them, then they are also victims. It's a dual motivation crime, something I've dealt with for many years in my home country, one good, one bad. If there is a bad motivation, a bad mens rea, you chase a guy out because he's a Muslim, because he's in Srebrenica, because you have this policy to make the greater Serbia, you chase him out, even though he's a private with a rifle, you run him off your territory. You do that with the intent to permanently deprive him, even though that's not a requirement. But when it is permanently deprived, there can be no question he is a victim also, in our view.
Okay, I think you've answered, with that answer, what was to be my next question, which was whether the position of the prosecution is that the column, the members of the column, were also the victims of forcible transfer. And I take it is the prosecution's position that the column and the members of the column themselves, not just those who surrendered, but the column and the members of the column were part of the forcible transfer. Is that correct?
That's correct. And if someone wants to get into the issues of hors de combat and those issues, it's going to have to be someone else.
No, for my purposes, that's the point I wanted clarified. Now, I have some specific questions on this that you may wish to address, or it was the area that Mr. Mitchell dealt with yesterday. These are specific related questions on forcible transfer related, though, specifically to the accused Nikolic. So I'm not sure. I'll put the first question, which is in relation again to the forcible transfer. And I understood Mr. Mitchell's explanation yesterday as to the receiving of individuals who were forcibly transferred, those who had surrendered at the road, that the act of receiving or dealing with those who were received is what is being alleged by the prosecution with reference to the forcible transfer in Mr. Nikolic. My question is, what evidence is the prosecution pointing to show knowledge on the part of Mr. Nikolic that these men, primarily who surrendered, were forcibly transferred out of Srebrenica? What particular evidence would you direct us to on that question of knowledge? Because I assume you would acknowledge that the receiving of these individuals for it to become part of the crime would have to be with knowledge that they had been forcibly transferred. Simply accepting prisoners of war, for example, would not constitute a crime. So I'm asking for what the particular evidence is on that point.
Well, I can outline some of it. Perhaps Mr. Mitchell will help me with others. I would first point to Drago Nikolic's important position in Zvornik, which, as you know, is very closely connected to the Srebrenica enclave. They were involved in the restrictions of convoys. sometimes convoys came in to the area over the Zvornik Bridge as opposed to always through Bratanac. And we see many of the convoy documents going through Zvornik. And I seem to recall Vinko Pandurović saying that's correct, that that was a main staff thing. We didn't have anything to do with it. But you'll see there's some Zvornik Brigade reports where the one I recall is when they were taking medical sterilizing equipment and other things it appeared to us that they had no business taking at the Zvornik Brigade. And this was a process, as you recall, that was overseen by the security branch. And certainly in Bratanac, we have Momir Nikolic testifying about that. And I believe there's evidence that the security branch was overseeing the convoy entry and exit. That's normal, of course, because convoys are a security threat, potentially. Smuggling, things like that. So it's only a natural part of the security's job to know about that. So we can likely provide you with more evidence of the Zvornik convoy restriction, which should be in the brief section, and the security branch's knowledge of that convoy restriction, and then ask you to infer that should contribute to Drago Nikolic's knowledge that the convoy is being restricted. Also, Directive 7 went to the Zvornik Brigade. The commander knew about it. The history of the area was known to all the officers. And I think that is a very fair inference that they know the history. The Zvornik Brigade was massively involved in pushing the people down to General Morion, the enclaves being created, the convoy restriction. They knew that those people had run for their lives, that they were stuck there, and he clearly would have known of the operation to take down the enclave. And he would have known generally. Remember Colonel Lasic, the guy that never made general. You could tell why he never made general was because he got up here and said something like, well, I knew what every VRS officer knew, that we weren't, we're not going to live together, and that was the policy, something to that effect. He knows it from the Drina Corps. Drago Nikolic has to know of the policy and practice to move out the population of Muslims from eastern Bosnia. This was part and parcel to, remember Vinko Pandurovic's morale documents. We have them, I think, April, May. It's rife with the idea of bringing back Serbia to Serbs and getting rid of the Muslims. This is it's a propaganda calling card to rally the troops, and it's in many of Pandurovic's documents that have to go to Drago Nikolic and will go to Drago Nikolic, and he will absolutely know. This is something that helped give them hope, and that we're getting the enemy, including the women and children, out of our lives, so that we can live by ourselves, and so genocide will not be perpetrated upon us again, like it was in World War II. This is the propaganda that was being fed to everyone, and with the results to back it up, that they all had to follow and take part in, from convoys to seeing some of the operations that went on. I'm sure Drago Nikolic would have been aware of some of the operations. The 10th Sabotage got together with the Bratanac Brigade, I think it was June of '95, to go in to create havoc in the enclave. That is, given the connections, is something that he probably was aware of. But overall, his knowledge should have been fully aware of the big picture and the little picture. Remember, '68 knew that there were at least 3,000 people that had surrendered on the 12th and 13th. And the phone call from Drago Nikolic directly related to prisoners was clearly connected to the massive numbers of people that are surrendering. The Zvornik Brigade has to send buses down there. This is something that he should have been aware of. It happened very visibly. It had a potential threat to Zvornik. Zvornik troops were away at the time. Drago Nikolic, as the security officer, had to be very aware of what was going on down there, because the word, as you could tell, Obrenović knew very soon that there were people heading up in his direction. This would have definitely engaged the security and intel forces. And so when you keep track of the army and the soldiers that are heading in your direction, you clearly know that they're civilians, and the civilians are related to it, because they're completely interrelated. I want to just very briefly, it's really impossible to separate the separation of men and setting them aside for execution and the forcible transfer of the women. The same troops are doing it. It's not one little group that's doing the separating and one little group that's doing. They're all doing the same thing. They're using the same vehicles. They can't transport the men up to Zvornik until they get the women and until they get the vehicles from the women and children. Now, I don't want to go into my argument without an answer to a question, which, but that does remind me of, got to look at these things together. It's not separate. As Drago Nikolic is aware of the military threat, he will know the civilian connection to it.
You are saying that the same troops did it, but you refer to two joint criminal enterprises.
Yes, we chose two joint criminal enterprises to try to describe this god-awful crime, and we did it based on our knowledge and review of the law of joint criminal enterprise as it came out, and we frankly did not feel we could charge everybody with the murder operation that was involved in a joint criminal enterprise. We do believe that there may have been people engaged in one that were not engaged in the other, or merely, to the point of making it worth a criminal prosecution. That was done on purpose to reflect the best way to charge individuals without overcharging.
Yeah, but going back to Judge Prost's question, with your indulgence, do I read you well? Are you saying that there was no way anyone on the ground there could have understood the attack on Srebrenica, the final attack on Srebrenica, as possibly excluding a forcible transfer of the entire population?
I think the people in the officer corps that were familiar with the practices and the policies, such as Drago Nikolic and the others, would have been fully aware. It's unbelievably noted in documents, and is from the directives and orders to the Krivaya 95 to other things. The officers would be aware that this final push was meant to be the final unburdening of the area of Muslims. That has to be known, not to every soldier and every farmer in the trench, but this officer corps of the Zvornik Brigade under the leadership of Vinko Pandurović, yes, these guys knew it. They were fully engaged in it. As we heard, Vinko Pandurović didn't think they'd be able to do it because he thought UNPROFOR would get in their way. He was wrong about that. UNPROFOR backed off, or UNPROFOR backed off because of hostages. But they were very much aware of those enclaves. They were very much aware of those Muslims, and not least of which because the Muslims were a thorn in their side militarily. So this was a huge focus for the officers, the people, especially in security and intel.
Coming back to that issue, I'm sorry to interrupt.
Go ahead.
What would be the borderline that would distinguish those who would be responsible and those who are not responsible,
For forcible transfer,
given the dual nature of the attack order?
a soldier that takes part in an attack or part of the processes with full knowledge that a principal objective of that attack was to move out the Muslims against their will is responsible. Private, sergeant, lieutenant, on up. Now, practically what I charge in this tribunal with our mandate, but the mens rea is no different, but it depends on knowledge and level of involvement. I would say we'd have to have significant, substantial involvement, significant or substantial, and I can't remember which. Anybody remember? I'm going to be in trouble with Mr. Kramer. But once they have significant and substantial involvement with the knowledge of the criminal event, and that their actions will result in that, they're part of it. There's even law that when they can, you may infer that if situations where there's a reasonable likelihood that their conduct will result in that, you may infer that they intend the reasonable and likely consequences of their acts. I think that's even fair. In our case, that's not an issue. These people know what they're doing, and they know that their actions are causing the crime, forcible transfer or the murder. That's the intent I've spoke about.
Would you exclude the possibility of a soldier or officer who would follow the attack order while not obeying the illegal part of that order, given that there's a legitimate part of that order?
Well, I just spoke briefly of Popović on that point. He knows historically, he's very well aware of Bratanatz's families there. He knows he was the chief of police. He knows precisely what this was about. He received intelligence that civilians were there, that there were military-age men there. He knew that they were going to go in and get rid of those people. He's given an order to attack. He knows that the troops who he's under the command of are going to take part in that attack. He is a senior officer. I think he is guilty when he takes part in the attack. Now, you could tell from my closing argument,
Any soldier,
he's part of the attack. I don't really seriously, personally start getting any kind of a worry about him in that until he starts going into Potocari and taking part of the physical movement of the people and allowing the abuse and doing the separations. That's where personally I hammer Popović. His involvement in the attack, while I think is technically a violation because he knows it's criminal, he knows he cannot be involved, and he knows he is involved. If you look at even under the RS regulations, he's guilty. Whether personally we would have charged him had he stopped and reversed out of Bratanats, I can tell you we wouldn't have. But would he have technically been guilty? Yes.
If you could expand further why you think Mr. Pandurovich is guilty in this respect.
In that, well, it's fundamentally the same. Vinko Pandurovich, as we have seen, he has pointed out, he was at the meeting in was it 93 with Karadzic. He was at Volksanica in 95 with Mladic. He was one of the premier officers of the VRS. He went on to be Minister of Defense. He's a published author. He was a significant force and a man and thinker at the time. He, better than anybody, knew the objectives. Look at those morale things. He knew the objective was to throw them out. He's been following Directive 4, following the orders. His knowledge was immense. His intent was immense. He was the one that issued those morale orders that glorified the moving of the Muslim population out of the area. So he knew precisely what this was about. And he is the kind of guy that has the ability to affect change and say, no, Turnovo is where, trying to suggest change. Now, his career would have been over had he done that. But so he goes into this attack with incredible knowledge on what the results are going to be should they be victorious. Now, had Nasser Orich been there, had NATO done a more effective bombing campaign, and had the UN forces been able to protect the Muslims, well, Vinko Pandurović would have been sent packing along with General Krstić, and the Muslims would still be there. But that's not the way it happened. And once the ball started rolling and the victory started mounting up and the massive population starts leaving, then it becomes no more gray area, Your Honor. Vinko Pandurović is still there. He's still engaged in it. And it's not just him participating in that initial attack. The gray area of when I personally begin to see criminal conduct I can charge is when the attack is successful and the civilian population is being targeted and the mortars are falling on the people either side of the road as they're leaving. This is the 11th of July. Vinko's forces are still there. He's still around. He's telling Mladic, we got to, get the weapons up on the hill. The Muslims are still around. He's fully engaged. So that's when I have no problem putting the forcible transfer right into Mr. Pandurović's lap.
But Mr. McCloskey, just on that same point, just as Mr. Pandurović is aware of, on your description, is aware of the background and the forcible transfer issues, he's also very aware of the military purpose behind the attack on Srebrenica. So is it your position that he's to say no to the attack? He's to say no, pressing the attack further, knowing that there's this dual purpose that you've described to the attack?
Yeah, I don't think the law can allow for a huge gray area here. I think commanders need to know what is against the law and what is not. When a person has such a clear object, an illegal object, as written down in Directive 4, as written down in Directive 7, as part of an entire war plan, when they see that that is happening, yes, when they start fully engaging their unit, they should say no. And that is the incredible duty of the commander. He has to say no under the law here, under the Geneva Conventions, in my view. Now, because it's his intent, it's his mens rea, his joining the joint criminal enterprise that are at here, and all of that's happening. He's intending to do it. He's knowing and doing. He's participating in it. It's a substantial part of the operation. It can't be that, when things start to go bad, it gets criminal. I mean, how is a general to know when it's criminal and when it's not? It's criminal from the beginning. That's when they have to say no. Now, had he taken part in this and stood down or written reports condemning everything and refusing to have his people involved in it and done and helped the UN and people and been honest with us about when he was in Potočari and when he was in Bratunac, then that is a horse of a different color. But when you have a policy like this that's so clear from the get-go, I don't know in the next 20 years where we're going to see something that's so clear as this. The 6 strategic objectives, the Directive 4. This is such a massively horrendous thing. Please, and I'll say this briefly, don't underestimate the horror of ethnic cleansing. This is a policy of ethnic cleansing. Yes, it has a military aspect to it because of what the Muslims are doing, but this is just as much as part of the policy of ethnic cleansing as anything you'll see in this case. And ethnic cleansing is worse than lighting a building on fire full of people. It's lighting a war, lighting a country on fire. What they did in Kamenitsa and Srebrenica, it was a long end of a long series of horror that was not necessary. It's not necessary in war to do what they did. And Srebrenica was the final culmination of it.
One question which is related to what you have been saying and what you've been asked. Is it the prosecution's position that the aims of Directive 7 and 7.1/1 couldn't have been completely achieved by the Krivaya operation, Krivaya 95 operation alone, but without the specific attack, final attack on Srebrenica itself, and the forcible transfer of the population?
I'm not sure I completely understand. I think Krivaya 95 was not meant to be the final, I don't want to say final solution, but it was not meant to be the final objective or the final movement to make Directive 7 happen. It's in the wording of the Krivaya 95. It's clear. It's creating the conditions to create the elimination of the enclave.
You have understood perfectly well my question.
Yeah, yes. So Krivaya 95 was there to create the conditions to be able to follow through and get rid of the Muslims, but just create the conditions. Pandurović is concerned that the UN would stand firm. Would have meant that they couldn't have gone any further, and so Krivaya 95 was only chapter 1 in what they hoped to achieve. Well, with Pandurovic's success, his military success, and remember, he knows the objective and he is fighting hard. Then the Krivaya 95 also says somewhere in it, be ready to take advantage of the situation and move forward, something like that. All military plans have that. And so on July 9th, Krivaya 95 becomes the possibility for the final objective. That's why it's so important. Tolomir is sending Karadic's message that they've agreed with what must have been Mladic's proposal to the IKM, to Guerrero, and to Krstić. Hugely important thing. They've changed from a Drina-core plan to create the conditions for the elimination of the enclave to we are now going forward, the enclaves are going to be eliminated. The UN is weak, the Muslims are weak. Full speed ahead, Krstić, Guerrero, Pandurović, Mladic, Militic. They're all involved, and then it becomes massive. And then it's the final objective. But no, Krivaya 95 didn't start out that way. It was meant to be the beginning, then to roll on to Gorazda, which they never managed.
Judge, you're done for the moment. Do you have questions? All right. Go ahead. I'll put a question to you it has multiple questions in one, basically, but you need to focus on the principal part of it. Who do you consider, as regards genocide is concerned, who do you consider for the purpose of the alleged crime of genocide to be the targeted group? And I'm asking you or whoever will answer this question for the following reasons. That, for example, we heard yesterday Ms. Soljan referring to the Bosnian Muslims in eastern Bosnia. Sometimes we've heard others yesterday and the day before, but also throughout the proceedings of this trial, referring to the Bosnian Muslims in Srebrenica and Zepa as being the targeted group. Also, there seems to be some sort of incongruity in the indictment itself. For example, paragraph 30 of the indictment refers to the killings of Muslim men from Srebrenica. Paragraph 26 refers to both female and male members of the Bosnian Muslim population of Srebrenica and Zepa. Paragraph 33 refers to the entire Bosnian Muslim population of eastern Bosnia. Basically, since this is one of the issues that we will have to determine for the purpose of the count charging genocide, we need to know exactly what your position is as to which or who was the targeted group for the purpose of the genocide charge. Yeah.
Well, we describe the group, which is, as you know, the statute says a group in whole or in part. We are, of course, talking about a part. And the group is the Muslims of eastern Bosnia. And those are defined as the Muslims of Srebrenica and Zepa, and should include Gorazde, but primarily Srebrenica and Zepa, though Gorazde is also part of eastern Bosnia, and they were also the focus of the ethnic cleansing campaign, as you've seen from the evidence. On to Gorazde. Gorazde is next.
Thank you. In your brief, final brief, you deal with some length with regard to the Turnovo killings and the involvement of the Scorpions unit. My question to you is, what evidence are you adducing? Because it's not clear from the final brief itself, which allegedly, what evidences are you adducing which would connect the Scorpions unit itself, which allegedly committed the killings in Turnovo, with any of the accused in the present case, or for that matter to any other member of the alleged JCE?
Well, just to remind the court, factually, the 6 or 7 victims from Turnovo all went missing. I don't know if it was Popović or the Woods, but clearly they were just like Orhan Suljic or Mevlud and Oric. They'd been separated, and at some point within this July time period, got shipped all the way across Bosnia to Turnovo. Now, we see Muslims getting turned over from Serbia to Bratunac and being shipped to Bišina so at the July 26th time period, I think, 23rd. And we see Muslims going across the river in late July and with the Serb forces after them. But so these are Srebrenica victims that get arrested in the Drina Corps zone of responsibility. And I think you can infer they end up in Turnovo because buses or trucks are going back to Turnovo that were used in the forcible transfer operation or murder operation. I can't think of no other reason why you would send somebody all the way to Turnovo, except they had troops there ready to do it. You put the Muslims in the vehicles that are going back already, and you send them to Turnovo. Well, that's across Drina Corps and other corps lines. It's that has to be managed by the main staff. You don't send, and it's not just 6. They're not sending 6 people in a minivan all the way across Bosnia. I think you can infer that this is a busload or a truckload of people, and they're being shipped there to scatter and hide this horrible crime. And so the logistics of doing that, the fuel, the vehicles, that all involves coordination from the level of the main staff in order to do it. Someone has to connect with the forces on the ground. Remember that the forces on the ground in Turnovo are these joint forces of Army and MUP. If you recall, Borovchinin was commanding such a force when he was shipped over to Srebrenica. He had the Scorpions under his command, and he was reporting on them on the end of June and July, the Scorpia, the Cayman, the others. So someone had to contact either that MUP or the Army. It was the Army. Borovchinin was working, as per regs, he would have been working under the command of the Army. So someone would have to go to the Army commanders in Turnovo, whether that was the Sarajevo-Romania Corps people or it would have had to have been at the corps level. That would have to go down through the Army command to the MUP command, because the Scorpions wouldn't be able to do any orders until their MUP guy, their equivalent of Borovchinin, whoever he was at the time, they would have had to go through him to be able to get him to engage these guys. Yes, we have to make some inferences, but you don't get Srebrenica victims transported with the fuel and the vehicles and given to a very well-organized, disciplined Serbian unit without massive communication and organization at the highest levels. That's inferencing, but you cannot get across the country without fuel, without vehicles, and the approval to do it.
But are you pointing your finger to any of the accused in particular, or to all those who took part in this particular joint criminal enterprise?
No, I'm for Turnovo, I'm not pointing at these accused. I'm not going to point at the accused for executions like that unless I've got evidence of the fuel, of the more something. I'm going to want some hands-on evidence before that. I can tell you that it would be almost unimaginable for the chief of operations not to know that they were shipping large numbers of Muslims across the country to be murdered. His involvement, his actual awareness in it is too fuzzy to point any fingers.
Okay. You're not alleging that the Scorpions unit was part of the Zvornik Brigade or under its responsibility?
No.
In other words.
No.
Thank you. Yes.
Could I get some more?
I'll ask you a couple of questions on reburials, and then I'll give opportunity to my colleagues, and then I'll come back to you later. Within the context, Mr. McCloskey, within the context of the tribunal statute, the law, and the indictment, is it your position that reburial itself constitutes a crime and that it's being charged as such?
Crime punishable pursuant to our statute.
Yeah, a crime punishable pursuant to our statute, in other words. That's why I mentioned initially the statute.
By itself, no.
Okay.
No, it has to be done with the knowledge of what the purpose is and in furtherance of that purpose.
Okay.
So that was the question. Somebody who didn't participate in killing before, or genocide, not at all, participate in reburial. It is your case, he's responsible for genocide or killing, for whatever.
Well, we do believe that the JCE continues through the end of the reburial. And if you brought an officer in to make sure, let's say they brought some guy from Serbia because someone else was busy. They brought in a specialist from Serbia to make sure that these burials went according to plan and were part of, and really done quietly. That would be a substantial contribution to it, and I think the issue would be a sentencing issue under our law. Now, we're talking about soldiers and bulldozer drivers and things like that. No, but if an officer comes in and is really providing a substantial and significant part to keep this quiet. See, murder, you've got to cover up. At home, I had cases all the time. You've got to keep it covered up and keep it covered up. Mass murder is even more important. So burials and reburials and mass murder has to be viewed differently than we may look at things domestically. So if someone comes in and provides some substantial assistance to something that important to keeping this from the international community and keeping this crime quiet, yes, I would say that that would be a substantial and significant contribution. We sometimes get a bit spoiled here. With a couple of less survivors and without aerial imagery, we may not have known anything. They could have been fully successful in this. The amount of luck and it was the international community getting into Bosnia in January that allowed this to happen at all. And so the ability to come in and keep things quiet, be it Afghanistan, Iraq, the United States, or anywhere else, is a big deal.
Yes, Mr. McCloskey, always on the subject of reburials. I've got a few more questions. You seem, if we understand you well, to be charging reburial as a natural and foreseeable consequence of the murder operation.
Yes, correct.
Could you expand on how you consider that reburials legally can qualify as a natural and foreseeable consequence in the circumstances of the case? I mean, people like the ones you charge, Nikolic, Pandurovic, Popović.
Well, fundamentally, I view it in two ways. One, as any murder, you have to dispose of the body if you want to get away with it. I mean, that is a typical part of any kind of a normal murder, and it's absolutely foreseeable that the police or somebody are going to be able to figure out where you hid the body, especially when you have to act quickly in the eyes of neighbors or the international community in this context, and that it's absolutely foreseeable that you might have to move the body. Now, I take my neighborhood murder example, but it's even more important on an international mass execution level. It's got to be, mass executions 101 has to be where to rebury the bodies when the internationals figure out where they are and how to do it. In fact, we taught them in Kosovo, they didn't do mass graves anymore. They killed people and left them lying and stuck guns under them because of what they learned from Srebrenica, in my view. So it's absolutely foreseeable that people might find where you buried mass bodies, and they might, and that you need to have a plan ready to do something about it. Especially near the end of the war, you know, that's, in my view, that's foreseeable that you have to hide the body from the authorities if they get close.
Thank you. You also charge. Yes, Justin.
Just on that one same question, the timeline is quite different when it comes to the reburials compared to the burials, naturally. So the reburials would in time be quite a bit further away from the killings and the burials. And this do not, in the prosecution opinion, make any difference.
Well, it could. As you know, the burials took place from 14 July through 17, 18, 20 July, the initial burials, and the reburials started, well, the fuel started, we see the fuel coming in, I believe it's September 15th from the main staff. So we have a few months. That's not very long in my view. It's a couple of months. The longer the reburials were from the actual crime, it would depend on the circumstances. But the circumstances in this case are pretty clear. In July, there's no immediate thought of Dayton. Well, the end of the war is considered near. That's one of the reasons why they want to push toward Srebrenica. The idea of NATO forces or people like that on the ground is really unthinkable. And that's one of the reasons why you see them acting so arrogantly, and that documents can be written the way they're written and only get found with search warrants. And so early on, in July, it was not a major concern, even though it should have been. But August, September, Madeleine Albright and her photographs in front of the UN showing disturbed Earth, that is all pretty quickly happening. And so it's after Madeleine Albright, who's in August, I believe, that in September we actually see the fuel getting there. So it's, you know, burials in July, UN photos to the world in August, reburials in September. Boom, boom, boom. No big delay, no change of personnel, no other reason to be doing this. This idea that they had to rebury people for hygienic reasons, no. So I fundamentally agree with, you have to look at the timeline and you have to see how connected it is. But in this case, very connected. As I just mentioned, that's the outline of burials in July, the world knows in August, the fuel comes in September, and the bodies start dribbling through Bratelnac and Zvornik in September and October.
Sorry, Mr. McCloskey, just one more question on this, for me anyway, on this particular topic. This whole question of foreseeability, I want to make sure I understand you completely. On your argument that the reburial is particularly, and Mr. Elderkin argued this yesterday, a contribution. It doesn't really matter then on your position whether it was foreseeable or not. At the end of the day, it's another factor going into the contribution. And foreseeability, which sometimes can bring into confusion that there's some allegation of JCE 3 here, which is what I was not clear on. My understanding, though, after Mr. Alderkin spoke yesterday, was that at the end of the day, the foreseeability factor is really not that significant on your argument of contribution.
Yeah, Mr. Elderkin's absolutely correct, and we put a lot of thought into his argument, as did he, and that's what we came up with, and that's why that was specifically mentioned by him. JCE 3 and foreseeability is another issue.
Thank you. I think I have your point now.
Since you mentioned JC3, I have a question about particularly the extended form of joint criminal enterprise. You charged the accused for opportunistic killing pursuant to that form of responsibility. The requirements for that is not only that it was foreseeable, but also that the accused took the risk willingly. So if you could explain to me what evidence we have as to whether or not and how the accused willingly took that risk. I'm particularly interested in knowing with respect to Generals Guevara and Milicic, because they were not charged for any killing except for these opportunistic killings, while others were.
Yes, well, General Milicic and Guevara, while noted as members of the joint criminal enterprise to kill people, were not charged. And the foreseeable, the opportunistic killings were specifically connected to the foreseeability, to the forcible transfer charges related to Generals Guevara and Milicic. And so that's a separate issue. And if I get your question right, it's their willful and intentional involvement and substantial assistance in the ethnic cleansing of Srebrenica that provides the foundation of their, that makes them responsible for the foreseeable actions. When there's no question in my mind that Generals Guevara and Milicic are fully versed in the horrors of ethnic cleansing. They see it not only from the Muslims, as they're driving the Muslims out pursuant to these directives, they see it happening to Serbs. Grahovo and Glamac. If we start this tribunal over again, I would love to go to Grahovo and Glamac and see what happened there. But, so they see ethnic cleansing from both sides, and they see how horrible it is. They see what happens when Western Slavonia, for example, we see what happens when the Muslim forces go in to clear out an area, and what they do to some of the Serbs. So they see it from both sides. They know precisely what this means and how ugly it is. It's more than foreseeable. It's a surety that soldiers seeking revenge are going to act out. Look at General Guevara's Order of the 13th. He is actually telling his soldiers that this Muslim column is going through, and among them are inveterate criminals and villains, and you must stop them at all costs. You know, you might as well say they're going to rape your children and wives. This is what, you know, the soldiers on the ground are getting fed, that the Muslims are coming to commit genocide on you. This is the bile that General Guevara is selling. He knows that when some Muslim is getting captured by Serb soldiers who have lost family members and have been given this steady diet of bile, they're going to act out. It's more than foreseeability, it's a surety. But certainly Milicic and Guevara, who have seen the ethnic cleansing and the results of it, can foresee and did foresee that the ethnic cleansing policy would result in deaths.
My question was not the foreseeability, whether they took the risk, but I think that your answer would do. But at the beginning of your response, you said that Generals Guerrero and Miletic were noted as members of the joint criminal enterprise to kill people. Could you draw my attention to that passage?
There's an annex, I think it's an annex in the indictment where we, as you know, I think the law requires us to list those that we feel are in the joint criminal enterprise to kill people. And we listed them in there. It is paragraph 97. And we didn't do it without evidence to support it. We have not argued it. We have not pushed it specifically because we didn't charge it. But when required to put down who was in it, we put it down. And I can highlight the evidence of their involvement if you wish.
Thank you.
McCloskey, I have a final question on reburials. And it's more of a clarification that we require from you than anything else. In the indictment, you specifically charge accused Nikolic, Pandurovic, and Popović with in relation to reburials, with regard to reburials. In your pre-trial brief, and for the record it's para 302 thereof, you seem to add Beara, and we've had in the course of the proceedings heard submissions, particularly from Mr. Stojic on that. In the final brief, paras 1079 and 2282 and 2283, you once more mention Beara as being involved in the reburial operation. Incidentally, you also allege in your final brief that the VRS main staff coordinated the reburial operation with Miletic's knowledge. Question is, what is exactly your position as regards reburials vis-à-vis both accused Beara and accused Miletic? Have they been put sufficiently on notice that ultimately they were going to be brought into this overall picture when they were not as such included as such in the indictment?
Mr. President, I remember discussing this with Mr. Stojic and some evidentiary matters related to it. And I would need a small break to go back and see where we are on that, because there may have been some changes or something. I need to, let me look into that. And General Miletic, we would have, Chief of Operations has to know about something this and has to be involved in it and know fully that it's happening. I mean, that's what that would be about. But if I can get back to you on the BR and maybe discuss it with Mr. Stojic, I think we can sort it out.
Yes, Mr. Stojic.
President, thank you, Mr. President. I would just direct the prosecution's attention to the November 8th and 9th transcript where we had the discussion and what I thought was a ruling from the court specifically on the 9th of November 2006. And we can have that discussion.
That's the reason why we have brought this up, because the subject is returned to in the final brief. So, okay. Mr. McCloskey accused Nikolic and Guerrero in the final briefs, respectively, make the point that the protection provided by the Geneva Convention 4 can only be applied to civilians, intimating at the same time that prisoners of war and detainees whose detention is justified cannot be considered as victims of forcible transfer or deportation. I don't recall this point having been touched upon in the course of the various interventions. Perhaps if you could deal with this.
Yes, Mr. President, that issue, I think, was dealt with in the Vukovar case. There were some trial chamber rulings about those victims, and the holdings that come out of the appeals chamber, I think, are important here, and I would have to refer that to my colleagues for a discussion to become updated on that.
Okay. So I take it you will deal with this later.
Yes, please.
All right. And yes, while we are at that, Judge Prost is drawing my attention to another issue that we meant to raise that perhaps you can include with this one and come back to us at a later stage. That's the duty to protect prisoners, particularly within the context of the Mrksic standard as contrasted with the Blaskic considerations. Yes. Borovchinin argues that the Mrksic standard can only be described as aiding and abetting by omission and should not be used as the prosecution has unmistakably pleaded Blaskic liability in respect of the duty to protect prisoners. That is the intentional omission, direct intent, which is intentional. Perhaps you can deal with this either now or later, but we meant to raise it now as worthy of some feedback from your team.
Yes, Mr. President. The Borovchanin brief says that we did not charge aiding and abetting for forcible transfer. And when I read it, we checked the indictment. Everything's being charged with aiding and abetting. It's very clear in the indictment. I think they're suggesting that this particular form that we've chosen, Mrksic form, the Geneva Conventions, what the defense, I think the defense expert referred to as the duty to protect. I don't understand why they don't think we've charged aiding and abetting on that as well. However, I have assigned Mr. Van der Puye to deal with that issue, and I'm sure he's prepared to deal with it.
Okay.
Especially if you give him a moment or two.
And, would you prefer to deal with it now or subsequently?
Thanks, Mr. President, and good afternoon to you. I am prepared to deal with it now to some extent. The problem is I'm not entirely clear on what the defense position is on it, but to the extent that I can assist the trial chamber with our position, I can certainly do that.
What I'm particularly interested in, Mr. Van der Puye, and I'm sorry I can see you only on the video screen, but is the prosecution alleging aiding and abetting by omission the Merksich standard. I'm particularly interested in knowing whether that is an allegation that the prosecution is pursuing on the facts in relation to Mr. Borowchanin.
Thank you.
I can answer that simply. This indictment was made, obviously before Merksich, and we intended and wrote aiding and abetting on each and every one of the statutes and forms of liability. That's the way it was meant to be pled.
And so what you're saying is that that would include any aspects of aiding and abetting that have been developed in the law, even if they're developed subsequently?
Absolutely, absolutely, and that's the way it is.
For my purposes, at least, it's clear enough. But since this was a question that we had agreed to put together, are you satisfied with this explanation as well? Yeah. Okay. Mr. McCloskey or whoever, we have had a submission from Borowchanin in his final brief that as from 9th July 1995, AMPR4 soldiers are to be considered as combatants for the purposes of the law. There are some allegations from others that could have been the position even before the 9th of July. But let's stick to this Borowchanin submission. What's your position on that?
I'm not sure how fully relevant that is, but as I mentioned in my argument, I don't have a fundamental disagreement with it. As they mentioned, there was the Green Order, and on the days leading up to and on the 11th, there was some very minor resistance from Dutch Bat, and NATO got in the game and dropped some bombs. So to that degree, UNPROFOR was a potential target, especially if attacking or perceived to be attacking the Serbs. I have no problem with Vinko Pandorovic going in to a UNOP that's firing on him and taking away their weapons. I don't have a problem even if they're not firing upon him, if they come in to the OP and taking away their weapons so that they don't get shot in the back by a Dutch soldier. I have no problem with that. Now, as I mentioned, once the hostility is over, and we're at the 12th of July, and the Dutch are sitting in their compound and standing around trying to look after the Muslim population and themselves. Mendeleev Djuric and his unit of deserters systematically disarming Van Dyne's people, Rutten, and pointing guns at him and taking away their ability to protect the Muslims that they're in charge with protecting in themselves. Now that's another matter. That is done with the intent to move forward the joint criminal enterprise to get at the population, either to separate and kill them or to move them out. And that's the conduct that I focus on. The other conduct related to what's going on with the OPs and NATO and all that, we've not charged anything like that, and I don't see. It makes good reading, but I don't see how relevant it is, and I don't really object to it.
First,
Your Honours, could my client be excused, please?
pardon?
Could my client be excused, please?
Yes, of course, yeah. Shall we continue, Mr. Joss, or?
We can continue.
Okay, thank you. Judge Prost.
Mr. McCloskey, I want to be very sure that I'm clear on the prosecution's position on this. It's obviously a very significant point. And you spoke about it this morning, and it's obviously referenced several times in the brief. It's the issue of the command of the Zvornik Brigade's involvement in terms of the participation of various aspects of the Zvornik Brigade in the course of the process with the prisoners and the executions. Is it the prosecution's position that first Obrenović and then Mr. Pandurovich specifically knew and authorized the participation, for example, of the various battalions that you made reference to this morning? Or is it your position that, more vague, if I could say, that it fell within their authority, that there was general command authorization for participation, and then the battalions fell in line, if you wish, behind that general authority? Are you alleging specific knowledge and authorization for the participation of the various units, other than the ones on which obviously we have direct evidence on, but the other extensive participation as you described it, Mr. McCloskey?
There's no question in my mind that Vinko Pandurovich and Obrenović were aware that the command elements of the battalions in the areas where these prisoners were held were involved. They would have known that. They would have had to known that. The particulars of the movements and how it all went, not necessarily. The actual, what Srečko Achimović was doing, perhaps not. But Vinko Pandurovich would have had to know. He needed the members of that Achimović's unit. He had to have known Achimović was involved in this horrible, massive thing that was taking him away from his duties at the front. He would have had to known that Achimović personally and that his units generally were engaged in that operation. He had to, so he could know how many he could bring to his front, how many he could ask for, what kind of demands he could ask from Achimović. Same thing with the 1st Battalion up in Pilica. You know, there's lots of in the record about the people in Pilica because they were a bit off the combat track. They were constantly being used to go other places. And Pandurovich had to know that there was a significant number of prisoners that were having to be dealt with. When he says the additional burden for us is the obligation of security for the people in the schools, he knows that the people in the schools are the obligations of his soldiers to guard. That's what's happening on the 15th. 20, 30 soldiers of the 1st Battalion, when he writes that, are guarding people at the Kula school. And there are people at Ročević. The MPs we've proven are at Ročević on the 15th. And the various units and soldiers of the Ročević Battalion involved in the killing. He has to know all of that. This is why he writes this thing on the 15th, because it's a burden and it's a total irritant to him on what he needs to do, and that's defend his lines and defend Zvornik. He has to know that. The absolute particulars of an involvement, he never needs to know absolute particulars, but he's the kind of guy that's going to need to know the details. He needs to know what his commanders are doing and that they're getting the job done. And he is going to demand that. He's at the forward command post. He's fully involved in communications with people. And he will know that his units are involved, and that is a massive distraction from him and what he really needs to be doing. And he has to know about it.
So then there's a quote or a statement that's attributed a couple of times. It's mentioned in the prosecution's brief, attributed to Dragan Jokic, where he says, Vieira, Popović, and Nikolić were doing what they wanted, taking whomever they wanted, wherever they wanted. That suggests, of course, the other position, which is that the security officers were carrying out these activities with the battalions without the authorization of the command. I take it then it's the prosecution's position that that's not a correct statement of what was happening. Because I don't think you can have it both ways, Mr. Mikulski.
Well, I wish Mr. Jokic would have been more helpful, but from Mr. Jokic's perspective, who is a civil engineer at the same time as a career officer, he's a weak character that when Beara comes into his office and starts saying, I need this and I need that, and Popović is there also, and Drago Nikolić is, and they're all saying, I have orders from my commander, that. They're not coming in and doing things without the orders of their commander. What I would point you to, as we've done it before, is in Zvornik, the first thing Drago Nikolić does is he calls his commander. Before he can do anything, he calls Dragan Obrenović and seeks his authority. Even Beara can't come in. And Beara is armed with Mladic's orders. But even Beara can't come in and say, I have orders from Mladic, give me this. He couldn't get troops from Blagojević or Nastic or the others. He had to call Krstić, General Krstić, please get these guys to give me troops. The security branch is having to go to the command in order to get what they need. They can't do anything on their own. All the people and the logistics and the units that they need to get this massive job done are under the command of the commanders, and the commanders have to be involved in that at that scale. Yes, a very small scale. Beara could come in and order this and maybe take a prisoner out and have him shot and the commander could conceivably not know about it. But 5,000 people in the schools in a process of from 13, 14, 15, 16, and 15 and 16 in particular for General Pondorovich, involving the massive aspects of look at our brief. I didn't have time to go over it. From the logistics and the fuel and the battalions, the amount of energy and resources that went into this, there's no way these three guys could begin to do that. Momir Nikolić reported to his boss. Drago Nikolić reported to his boss. Popović, as Mr. Van der Puy has reported to his boss several times. And Beara was getting called by his people 155 several times during all this and having to report back, and they're calling him. These are the command nodes running their security branch. This is not the security branch running the other way around. That is the tail wagging the dog, and it's just historically, fundamentally impossible on this scale. It can't be done. They can't come in and just take what they want and do what they want at that scale. There's only 3 of them. They need the military police who are under the command of their commander. They need the units, the drivers, the other folks.
Okay, thank you. I have your point. Thanks.
Let me see if I could run through these. I have got some minor question. Miletic final brief, page 9, para 16. There is a statement there that General Milovanovic himself acknowledges that in the spring of 95, and in any case from March to late May 1995, he was at Chirne Rijeka with the consequence that therefore no one could have stood as chief of staff or as deputy chief of staff, etc. Do you accept that that part of the evidence that Milovanovic was in Chirne Rijeka, particularly from March to late May 1995?
I'd have to check with Mr. Thayer. I do remember, should be in evidence, is the collection of reports to the Supreme Command. I believe we got in a huge collection of those throughout 95, and some of them showed, a few of them showed that went out under the name of Milovanovic. during periods of 95, and many others went under Militich's name. And we think that's primary evidence of who's around. But there's more to it than that, and Mr. Thayer is familiar with that. And again, I think if you give him a little bit of time, he can give you a more prepared answer.
Thank you. Same final brief, pages 85 and 86, paragraph 2 and 3. The Militić defense team makes the point that the trial chamber had taken judicial notice that, quote, the Bosnian Serbs deliberately tried to limit access to the enclave by international aid convoys. By early 1995, fewer supply convoys were making it through the Srebrenica enclave, and finally, that blocking aid convoys was part of the plan. This is what we are supposed to have taken judicial notice of. It is then submitted, basically, that the correct wording, exact wording, is that the defense was therefore at a disadvantage as the onus was on the defense to adduce rebuttal evidence, which to me means that this judicial notice basically led to a inversion or reversal of the onus of proof. Do you wish to comment on that?
I think it's clear that the adjudicated facts are something that does form a presumption, but it's a rebuttable presumption, which Ms. Favreau, General Militić were fully capable of doing, and it doesn't. And they would have done it, of course, anyway. In regard to our case, if the prosecution had stood on that alone, they might have some kind of a concern. But if we'd stood on it alone and they'd rebutted it, it'd be over. So the fact that they have to rebut it, yes, that does shift the traditional burden to some degree, I think. I may get corrected by that statement, but I think practically it does. But as we know, an adjudicated fact sits there. It's not something that you're going to, if something is hotly contested, I think everyone has faith that you're going to make your judgment on each side's case and not worry about your own adjudicated fact 3 years ago.
Thank you. Page 124, para 286 of the Militić final brief. Reads as follows: when an accused is alleged to have participated in a JCE, the nature of his participation must be specified, including the facts from which such an inference may be drawn. And there is a reference to some jurisprudence there. Then the same final brief continues: at no point did the prosecution allege that General Militić contributed or participated in the restriction of UNPROFOR logistical supplies. This cannot be put down to lack of precision in the indictment, but to an omission which cannot be remedied by the evidence presented. So basically this is attacking the integrity of the indictment as it relates to Militić. This is why I'm putting it to you in case you wish to make any comments.
Thank you, Mr. President. That is an issue that Mr. Thayer and I have discussed, and if we could put that on his list, I'd appreciate it.
Okay, thank you.
And Mr. Stojic, I think, is ready to answer the rest of our questions.
Leave Mr. Stojic alone. Let sleeping dogs lie.
Excuse me, Mr. President, I just wanted to correct the record on page 474, lines 19 through 22. It mentions that I said May 8th, but it's actually the 8th and 9th of November 2006. And particularly, I found that November 9th, the transcript at page 3876. Thank you.
Thank you. I think that deals with Miletic. Borovchany, page 19. Borovchany. I'm reading because otherwise no one would be able to follow. From paragraph 136. The combat with the column, which the prosecution in any event concedes was a lawful military target, was not conducted by the MUP alone, as claimed by Vasic in his dispatches. Vasic, for whatever reason, was apparently exaggerating the situation to his superiors. And then it continues, and this is the more relevant part. Third, not all the MUP forces were under Borovchany's command. The 2nd, 5th, 6th Zvornik PJB companies and the 2nd Deserters Unit were subject to a different chain of command and were not subordinated to Borovchany under Order 64/95. Borovchany suggests or believes that the prosecution has never suggested otherwise. Is he correct in this? In other words, that you have never suggested that the 2nd, 5th, 6th Zvornik PJP's companies and the 2nd Deserters Units were subject to a different chain of command?
I'm not sure we've dealt with it, Mr. President, because the units that were specifically in the area of Sandici and Kravica and located in Popović are very clearly defined in the case, and these other units go from more of the Lolici towards Kornevich-Polje area and are coming in at different times, and we haven't dealt with it, but I can tell you under the rules and under the conditions and knowledge of this case, it's impossible to think that they're going to be bringing in PJP or special police or PJP units working alongside Borovchany's units that are under the command of someone else. It can't work that way. It's not designed to work that way. Borovchany is an impressive guy. He can handle these MUP units. They're not going to give MUP units in the same area as Borovchany to some army commander or some competing MUP unit. So, though I don't find it super significant, but the position of the prosecution is very likely he's into the command, that he's commanding any of these units, if not more than likely. I would say he is. And I need to correct myself on one answer I gave when I said I had no objection to the disarming UNPROFOR in the various operations. As I'm thinking about that, this is, again, the problem of the dual motivation. When Vinko Pandurovic dismantles UNPROFOR with the purpose to get at the civilian population, that is a contribution to the crime. When he dismantles UNPROFOR because they're firing at him, that's not a problem. When you have both at the same time, it is a problem. He shouldn't be doing it in the first place because it's a crime to go into a United Nations safe area to drive out the population. It's a crime to go into anywhere to drive out the population. And if you take out any force to do it as a substantial part of making that happen, that's a crime. It doesn't sound good, we don't like it, but that's the case. This is a horrible crime.
when he himself has a dual motivation.
Yes. And the higher you get up in the ranks, the clearer it becomes. The lower the soldier that's being ordered to attack the OP or the lieutenant that's going up there, you know, is one thing. But the people at the top of the food chain like this that know from the very get-go the horror that's involved and what's going to happen shouldn't be happening. And when they do it, going after UNPROFOR, be it Gvero, be it Pandurovic, Militic, that, in my view, is a substantial contribution to the JCE.
All right, I had some other questions which I'm going to skip because more or less they have been even marginally dealt with earlier. Again, Borovchinen final brief, page 166, paragraph 277. I'm reading. Butler's view was that Vasic had no knowledge of the killing plan when he wrote a particular passage to which the previous parts of that paragraph refers, and that he genuinely believed that those men would be released as an inducement for the column of the 28th Division to surrender. If the question that Borovchinen defense team put is the following: if the killing plan was not obvious to Vasic, who had been privy to the two main meetings held by General Mladic, then how could it have been obvious to someone else who had been out in the field and not involved in any of those meetings?
It's probably best to have that report in front of you, but Vasic writes that report based on the 10 a.m. 12 July meeting at the Hotel Fontana, where Mladic is saying you know, to the Muslims, you survive or disappear. And what Vasic reports shortly thereafter, probably, I don't know, he didn't have times on his reports, but it's probably shortly thereafter, a few hours on the 12th of July, is that Mladic, in his view, Mladic is holding these people as a hostage to try to bring the men out of the woods. I don't know where he got that from, be it Mladic or not, but yes, in our view, Vasic at that point has not been told of the plan. And by that afternoon, 1 o'clock, the busing and separations it's beginning to get going, but it hasn't really got going yet. And so the real obvious, what's going to be clear to everyone is this lack of screening and this horrible abuse and the separations. This is where those that are not on the inner circle are going to start to become aware. Remember, on the 12th of July, Tolomir from, where is he, some outside of Žepa, writes a proposal, which is his job, and says something to the effect, make sure we get lists of these people so we can get down so the war criminals don't get away. This means Tolomir doesn't know about it. He's in Žepa. He has not been told, because you don't get lists, and that's what you do for exchange. That's the first thing you do, and that's what Tolomir wants, so that they don't exchange all these people without figuring out who the bad guys are. That's his job as security officer. So in the afternoon of the 12th, that's what he's writing. So Tolomir isn't in on it. There's an intercept. The same thing, it's on the 12th or 13th, where someone is saying, hey, they're getting large numbers of Muslims. We've got to get in there, otherwise we're going to get away scot-free. And the guy on the other end basically says, don't worry about it. So somebody on the other end of that thought that these Muslims that were getting collected at Nova Kasaba were going to be sent away. So the 12th of July, if you're not in on the inner circle, you're not going to know. But when you start separating people and treating them less than like as you would an animal, then the word spreads. The commanders that are doing it have to know what they're doing because they have a duty to look after these people, to make these lists, to get them ready for exchange so they can get their Serb brothers back. And the commanders like Borov Chunin that realize we're not doing that, they're going to know why. So the fact that Vasic in the afternoon of the 12th of July doesn't know, it's not until the separations and he's being engaged and he's communicating with the MOOP and Bratunats that he's going to be fully aware. As Miroslav Deranic basically said, when he saw that there was no real screening, he knew something was up. So that's the explanation to that particular part.
Okay, thank you. And last question for today, and it is strictly legal. Refer you to para 399 on page 225 of the Borovchinin final brief, and then to paras 411, 412, and 413, which you will find on pages 231 and 232. Basically, in the first of these paragraphs, the Borovchinin defense team is stating that taking the wording of paragraphs 30.4.1 of the indictment, they are understanding that paragraph as properly charging only superior responsibility and exclude that the paragraph properly charges Borovchinin with having committed the act described in that paragraph, whether directly or by way of JCE. If his contention is not correct, then he attacks the same paragraph by way of alleging that he was given lack of adequate notice of what he was being charged upon. Similarly, in the other paragraphs that I mentioned, in pages 231 and 232, he is offering a blanket objection to counts 3 to 6 and 8, alleging that they are vague, more or less mounting the same way of reasoning as in the case of the paragraph 34 or 81 that I mentioned before, and suggesting that the indictment in his regard does not charge aiding and abetting except insofar as the Kravitsa warehouse events are concerned. In other words, alleging that aiding and abetting is not being charged in respect of any of the crimes committed in Potocari, and that includes the forcible transfer and other forms of persecution. I consider this allegation as warranting some kind of feedback from you.
Thank you, Mr. President. We will do that. I can answer it briefly. It's ludicrous. I looked at his allegations that we weren't charging aiding and abetting. We charged aiding and abetting for all forms. So we'll look in the particulars of that. But I think we need to be careful here. Unless there's something that they can point out to that occurred at trial or some other issue, the time for challenging the indictment is long past. If they're going to challenge the indictment on these grounds, that requires all accused to get up and challenge the indictment on those grounds. This is one of the clearest, most detailed indictments in this tribunal, and we've gone through this entire process. And so unless there is some specific connection to the case that he can point to, the process is disconcerting, but we will absolutely answer your questions and be prepared to respond to it.
Okay, I think we can stop for today. I did have some more questions, but I think I will take the opportunity over the weekend to go through them again and see whether they need to be put or not. In any case, on Monday we will start with you, Mr. Jovanovic. And now we'll start with you after, of course, we've had the final response from the prosecution to the questions that we have postponed. Thank you and have a nice weekend.
I'll rise for you, Willoughby.